Well, good afternoon, everyone. We're going to go ahead and get started today. We're talking about cost-effective management of workers' compensation claims. Hopefully, you learned something today that'll help your company save a little money in the management of your workers' comp claims. There's a distinction between state fund and self-insured employers. We have a mixed group in the audience, so just run by that real quick. State fund employers are the employers that pay premiums directly to the state. Those employers, the Bureau of Workers' Compensation has much greater control over the cost of the claims. The Bureau makes all determinations regarding compensability, payment of medical bills. A state fund employer can sit back, defer to the Bureau, let the Bureau take care of everything, and just get involved when you want to on the issues you want to. But in a state fund claim, the employer itself has no right to subrogation. The Bureau has that. There's also statutory and policy preventative measures, which the Bureau will take, and any reimbursements are indirect after the Bureau gets their money back. Self-insured employers are the bigger type of employers, and they stand in the shoes of the Bureau, and they pay everything directly. But as with anything, great power leads to great responsibility, so self-insured employer is going to pay their claims costs directly. They've got to really take an active role in the management of their claims. Self-insured employers are also charge assessments on all paid compensation, and that can be a huge charge. A lot of employers don't even realize, but right now assessments are probably running in the mid 30%. So for every $100 you pay in paid compensation, you're paying the Bureau an additional 33% on top of that for the Bureau and the Industrial Commission basically to exist and run. So that's one of the reasons it's always a good idea to settle a claim, and I'll get into that a little later in the presentation. But self-insured employers, if they haven't opted out, can also get your money back, but that's a rarity anymore. But you do have rights to subrogation, so if a third party injures your employee and you have to pay workers' compensation costs, you can file action against the third party and get your money back. The thing to remember, and the Bureau takes this very seriously, is self-insurance is a privilege. They consider it that way, so you really have to follow the rules and do everything you're supposed to, and if it doesn't, it'll come up during an audit. There are preventative measures employers can take to keep their claims costs down, especially state fund employers. Participate in Bureau safety programs. The Bureau runs these several times a year. I would urge you to sign up for those because you can get a break on your premiums to participate in their safety programs. There are alternative rating programs. This is something to talk to your third-party administrator about to get your claims costs lowered. There's multiple rating systems out there. So if you're not familiar with those, again, call your third-party administrator and find out if there's something that can save you money. Handicap reimbursements are a really underused avenue to get money back, and you can use these for state fund as well as self-insured employers. Basically, there's a number of recognized handicaps under the law. The easiest ones I always point to would be like arthritis or diabetes. If an injury is caused or exacerbated by one of these recognized handicaps, you can take this to hearing and get credit to your premiums. The example I love to give on this is I had a client who was a small trucking company, and the truck driver, by all witness accounts, the truck just drifted off the road, never hit the brakes, and slammed into the side of a mountain. The truck driver died probably within a half hour after the accident. Traumatic, tragic injury. And I was reading an article online about it because it happened down near Kentucky, and the reporter indicated that there was a glucose meter in the front seat by the driver. So I talked to the employer, and they didn't know anything about it. So we did a really intensive search, got a hold of his records, found out the claimant was diabetic, and to make a long story short, we got medical evidence to show the driver went into a diabetic coma because he had not been eating properly, and that's why he basically passed out and never hit the brakes before he hit the side of the mountain. We took that to hearing. I was hoping for 100% reimbursement, but we got a 95% reimbursement. So the employer in that situation saved itself 95% of the cost of that claim. So that gives you an idea of the money you can save just by being cognizant of handicap reimbursements. Don't be afraid to take those to hearing. And the other key to that is don't be happy with what the Bureau initially gives you. Always take it to hearing. The Bureau is notorious for issuing low handicap percentages, if at all. Like, for example, in this one, if I remember correctly, the Bureau initially assigned about a 25% handicap reimbursement. So we appealed that, took it to hearing, and got it raised to 95%. So that's one of the big takeaways from today. Always look for a handicap reimbursement and never be satisfied with what the Bureau gives you. Take it to hearing. And ultimately, as a state fund employer, your goal, if at all possible, is to become self-insured. Once you do that, you control the purse strings. The overriding principle here is controlling claims reduces costs. And I'm always amazed at how many times employers do not take an active role in their claims management. Well, where does your money go? If you have a claim, if you're a state fund employer, it's going to cost you increased indemnity. If you're a self-insured employer, you're going to be paying medical bills, temporary total compensation, wage loss compensation. You're going to have increased reserves, and for all, especially the self-insured employers out there, you know, reserves are probably one of the banes of your existence. Once those reserves increase, it's money right off the bottom line. So increased reserves is costing you money. If you're a state-funded employer, increased premiums is like an insurance policy. The more claims you have, the more the Bureau is going to charge you, the more likely you are to get kicked out of a group. Once you're out of a group, your claims costs are going to skyrocket. So all of these things will increase your expenses, so staying on top of your claims from day one is absolutely critical. There's another great takeaway. Investigate before you certify. So many employers, for whatever reason, are in a hurry to certify a claim because, especially if they think, well, it's no big deal, it's just a low back strain or it's an ankle strain, or pick a diagnosis. But you'll want to make sure you do your due diligence and investigate any claim before you certify it. Because once you certify a claim, you can no longer take the position nothing happened. Once you certify the claim, the issue becomes how bad is it? So you're in the damage control. So I'd always say do your due diligence, get medical releases, get prior medical records. You want to find out if this claimant has had these type of problems before. Don't be in a rush to certify a claim once it's filed. Avoiding temptations. Don't get complacent. Don't think your program is going to run itself. You have got to stay on top of your claims. Failure to get an IME or property to defend a claim is going to cost you a lot of money. So do it right from the start. The first thing you can do, and it's not very expensive, is you can get a file review from a doctor. That doesn't mean there's no clinical examination. The doctor's opinion is going to be based on records only. It's much less costly than an IME, probably a third to a half the cost. But then keep in mind, you're going to be open to the argument, well, your doctor never saw the claimant, so it could have limited value in certain circumstances. But if it's the issue is not huge and you're going to take an issue to hearing, anytime you've made the decision, I'm going to fight something, I'm taking this to hearing, you almost always have to have medical evidence to support you. So a file review is the cheapest way to go. The best thing to do is get an independent medical exam. And employers say, well, that's pretty costly, but once you, as an employer, have made the decision to fight a claim, you got to know it's going to cost you a certain amount of dollars to do that. And if you've decided to fight a claim, don't skimp on an independent medical examiner, or as we call them, an IME. Now, the doctor you pick doesn't treat or offer advice. There's no doctor-patient relationship established, but picking the right IME doctor is critical, and providing that IME doctor with the correct records and asking the right questions is absolutely critical. So many times, the wrong questions are asked of the IME doctor, or they'll answer questions they weren't asked, and you can really put yourself behind the 8 ball. So have someone do this for you, and we do this all the time. There are companies out there that do this, but I always say garbage in, garbage out. So you got to make sure you give your doctor the right information and ask the right questions. For example, if you're dealing with a low back strain, don't give your doctor 1,000 pages of records regarding somebody's upper respiratory infection. Doctors don't want to spend hours reviewing irrelevant records. You got to make sure you give the doctor the stuff that's relevant. But deciding what's relevant is a critical thing, and that's why you got to have somebody who knows what they're doing go ahead and do these IMEs. Well, who's on your team to fight these claims or to manage your program? Start off with human resources got to be a part of it. Your safety department's going to be a part of it. Supervisors, your third-party administrator or actuary, and your lawyer. All these parts to your moving machine have to work together to make your program run smoothly. Safety is huge. I mean, you've got to have the safety department on board, making sure the jobs are safe to start with, and once you know if there's a problem in the plant, get it fixed. Frontline supervisors are absolutely critical. As a part of this presentation, I'm not going to get into supervisor investigations, but the thing I will say is that talk to your supervisors. Find out if it's even possible for an accident to have happened the way someone is alleging it happened. All these people have to be involved. Talk to your third-party administrator. Talk to your lawyer. 5 or 10 minutes at the start can save you a lot of money down the road. So make this a team approach and get the entire team involved. What are the defense strategies to controlling costs? As I said, monitor the claims closely. I actually had one shortly before I came in here today where someone has been on temporary total compensation since 2015, 3 years. I think there's a classic case of someone getting lost in the system. The checks just started getting cut, they're not there anymore, and people just forget about it. So you really got to stay on top of your claims. Have systems in place that if someone's on temporary total compensation or off work for any period of time, pick on it, it could be a week, a month, have your system flag it so that you can stay on top of that claim. The choice of not only the doctor to treat them, if you can steer your employee to the right doctor who will get them back to work. And what I see so many times is claimants going to doctors who are more than willing to keep them off work forever. Try to develop relationships with your doctors in that area and let the doctors know we can get people back to work. Nothing here they can do. We can get them back to work. So have an open relationship with the doctors who are treating your people, especially those in smaller towns where there's not a bigger choice of doctor. Another great defense strategy to control claims costs are court appeals. And so many times you have to appeal something to court to put it in a posture to either A, fight the claim and get it disallowed, or B, to try to settle it. An employer never has as much leverage as they do once a claim is in court. And that's because of a number of reasons. Number one, in the Industrial Commission, rules of evidence don't apply. When you go to a hearing, claimants and their representatives can pretty much say anything, file any evidence, get away with a lot. Once you're in court, rules of evidence apply. They've got to prove things. They just can't say something and have it taken as true. Plus, as a general rule, claimants' attorneys don't like the time it takes to do things in court. They want to get in and out of a claim fast. So by taking something to court and your ultimate goal is to settle it, a court appeal is a great way to put pressure on them to get that case settled and off your risk. Like I said, appeals to court, there's two. If you're a state fund employer, again, that can be a deterrent to claims. But keep in mind, in a state fund claim, if the claim is allowed, the Attorney General's office has to uphold the orders of the commission. So the Attorney General will do most of the work. However, they're not representing you, so you still need your own lawyer to make sure they have your best interest at heart. Why is that? The Bureau can get to the point where they think, well, we want to settle this claim because it's not worth our effort, or they think it's a good claim, whereas settling that claim could get you kicked out of a group. So just don't automatically assume having a Bureau attorney is going to be protecting you as the employer. You always should have your own lawyer. As far as self-insured employers go, like I said a second ago, it's a great way to fight claims and settle claims. And I've had many claimants attorneys tell me that once an employer has a reputation for fighting claims or taking them to court, they might not even file a claim in the first place if it's a little suspicious to start with. Why? Because they know that employer means business, so it's a deterrent to bad claims being filed in the first place. Claimants have to spend money once they're in court. There's court costs, there's depositions. You as an employer, if you take it to court and win, the whole claim is terminated. You no longer have future costs to worry about. It can be a means to settle the claim with a resignation, perhaps, if you have an employee that's not the best in the world and you're looking for a way to get rid of them. It avoids permanent partial disability awards, and it's a good way to terminate temporary total compensation. What are the ways to manage specific areas of compensation? Well, keep in mind permanent partial disability. That's one concept. You've all heard C92 applications or PPDs. That's basically the workers' compensation version of damages from like a car accident, pain and suffering. Because in workers' compensation, you can't get paid for pain and suffering, but you can get permanent partial disability awards. And when those go to hearing, it's every percentage of permanent partial impairment awarded equals 2 weeks of compensation. And although it's an oversimplification for our purposes today, you can consider a week of compensation for permanent partial purposes is around $250 to $300, depending upon the average weekly wage of your employee. So if 1% of permanent partial impairment is 2 weeks of compensations, every percentage of impairment is going to be, anywhere from $1,000 to $1,200. So if you had a 10%, a 5% award, that's 10 weeks of compensation. That can get to be, $5,000 to $10,000 in a hurry. So the permanent partials is something to take very seriously because it can get out of control in a hurry. And claimants' attorneys routinely go to doctors where they're going to get findings of impairment 2, 3, as high as 4 times the amount that is really there, because they know that the higher they get, it's going to offset the employer's report. And that's why, as an employer, don't simply be happy getting the Bureau report. If you're looking at a claim that has a 1 or 2% impairment, it's okay to rely on the Bureau report. But if you're looking at a claim with 5% or more, I would always urge you to get your own IME to keep the costs down. So really look at the nature of the claim, the initial award, to determine whether you're going to object to that initial tentative order. And keep in mind, too, permanent partial awards increase your assessments. So say if you have a $10,000 PPD award made, you're going to pay another $3,000 in increased assessments on top of that. So the more you can spend to keep that down, the better it is for you. You know, it goes back to what I said earlier. Assessments are a hidden cost that a lot of employers do not consider when they decide what they're going to spend to fight a claim. But like, for every dollar in paid compensation, another 30% or more is going to be in assessments. So that's always a consideration. Temporary total disability compensation. Never pay TT without a C84 and a Medco 14. I mean, I see so many employers that'll just pay with a disability slip. Fight the urge to do that. Make the claimant file the C84 and a Medco 14. They have to dot the I's and cross the T's before you pay them temporary total, because the one thing you know is once they're on TT, it is very difficult and it can be time consuming to get temporary total compensation stopped. Like I go back to the one we just talked about a second ago, it being paid TT since 2015. The claimants are getting the temporary total is tax-free. Claimant is more than willing to get tax-free money to sit at home and do nothing. So you have to keep that in mind. Don't voluntarily pay TT unless you have to. And if you've got a reason not to pay, I would always challenge it. Once it's started, when you're for a state fund employer, there are 90-day exams, and the Bureau should be on top of it. But if they don't do it, don't be afraid to call the Bureau and say, hey, isn't it time for a 90-day exam? If you're a self-insured employer and they're on temporary total, you absolutely have the right every 90 days to get a new IME. Find out if they've reached maximum medical improvement. Take it to hearing if you have to, because you have to be on top, and this all goes back to properly monitoring your claims. It's going to save you a lot of money. Wage loss compensation. This, frankly, is not as a hot topic as it used to be, because it's much harder to get wage loss than it used to be, but you still want to do your due diligence. Claimant has to do a number of things in order to be entitled to wage loss compensation. They have to do a job search. And in this economy, in fact, I had a hearing this morning with a large temporary agency, and I was talking to them, and I see this myself. In today's economy, employers are begging for employees. Temporary agencies are begging for employees. Unemployment is so low that it's hard for employers to get employees. So I am always very skeptical on a wage loss claim when a claimant comes in and says, I can't find a job. I said, well, here, I'll give you cards of 4 employers that are hiring right now. So as an employer, right now, I would fight almost any type of wage loss claim, because if someone really wants to work in this economy, they can find a job. The problem you have in today's world with job searches is how they're done. You know, back 10 years ago, people would have to go out and to brick and mortar establishments, do a job search. They had forms they had to fill out. Very rarely is that how people look for jobs anymore. Now you have Monster.com, you have Indeed, you have all these online job search programs. So theoretically, somebody could sit at their computer in half a morning and maybe send out 50 job searches. But how do you prove if they did that or not? It's one thing to sit there, allow the claimant to say, yeah, I went on the Monster.com and I applied for 20 jobs. Make them prove it. You want printouts of what they've done. You want them to prove they've actually done the job searches, because it's a lot easier to do it. And keep in mind, for wage loss compensation, the rules require that if you came from a full-time job, your job search must be full-time. In other words, they can't get up in the morning while sipping their coffee, be online for Monster.com for an hour, and they're done for the day. No, they're supposed to be looking for a job 8 hours a day. So don't hesitate to ask them, well, how long did you spend that day? If they say an hour, well, you're not making a good faith job search. If you're looking for full-time employment, you've got to be working at finding a job full-time. Another thing we'll talk to employers about is consider doing surveillance on a job search. If someone's actually going out and looking for jobs, spend the money on maybe doing 1 day of surveillance to have them filed or followed to see, are they really going to the places they say they are? We have won wage loss claims in the past when someone says, I went to 18 different employers that day and none of them were hiring, and we had them followed that day, and they went to one place and then went back home. So that's just another arrow for your quiver if you want to. And don't be afraid to get a medical exam to confirm what restrictions, if any, are necessary. Because they've got to show that they are prevented from working due to the restrictions based on the allowed conditions in this claim. And it's the rare claimant anymore that their only problem is their work-related problem. They might have 4 other non-industrial problems that are preventing them from working. So get an exam to confirm what restrictions are necessary for that claim. And then you get to the holy grail of workers' compensation, that's permanent total disability benefits. That means they get benefits for life. So if that's the case, you can see how that's going to cost you a lot of money. If you're a self-insured employer, that can cost you hundreds of thousands, if not, 7 figures, depending on the age of the claimant. If you're a state fund employer, hopefully by the time they file for PTD, the claim is out of your experience, and then you don't need to really worry about it. If the claim is more than 5 years old, which for most PTDs is going to be, you don't really have to worry about fighting it. It's the Bureau's problem. If the claim is still in your experience, you better fight it because it will cause your premiums to go up astronomically. But again, as a self-insured employer, when you see that PTD application come across, you've got to pull out all the stops. Utilize every defense you have. Consider surveillance. Is the guy really sitting at home on the couch all day like he says he is? Is he out working in his garden? Is he mowing his lawn? What's he doing? Find out. You need to do everything possible because if they're awarded PTD, the only way to get them off of that is basically to prove they're working somewhere, which is very, very difficult to do. And most claimants, it's the rare claimant that's crazy enough to go out and work under the table when they're getting PTD benefits. It does happen, but you want to spend your money up front to fight a PTD claim. Get your IME, possibly surveillance. Definitely take it here, and you got to have, get your legal team involved. Do everything possible. Settlements. Settlements are one of the best ways to control claims cost. You should work to settle claims if at all possible. I always tell employers that once they're a claimant is no longer your employee, don't let them out the door without trying to get that claim settled first. Because sometimes if they're no longer your employee, you have no control over them. You can't bring them back to light duty work. You don't really know what they're doing. So try to settle a claim before someone leaves. If you have a bad employee and you'd like them not to be your employee anymore, try to settle a claim with a resignation. But your ultimate goal should be to settle the claim and get rid of it. For a self-insured employer, especially if you've got a claim with a huge reserve, if you can settle that claim for less than the reserve, you've just freed up that money, which will go back to your bottom line. I settled a claim not that long ago. The claim actually had a $350,000 reserve. We settled it for $50,000. That means $300,000 went back to the employer's bottom line. So keep an eye on your reserves. If you can settle for less than the reserve, it's crazy not to. Beware of an MSA. I mean, it's hard to settle claims with Medicare set-asides anymore. You've got to protect Medicare's interest. You're going to get the Medicare evaluations, the MSAs. Depending on the amount of the settlement, you might have to file with the CMS. one way around that is an indemnity-only settlement. If you've got a claim that's got a lot of medical bills, or the guy is still treating a lot, and your primary concern is the guy's going to be permanent total someday, settle just the indemnity part of the claim. Then you don't have to worry about an astronomical MSA, which prevents you from settling. Settle like I said, the indemnity is the money part of the claim, your temporary total, your permanent total, your permanent partials. Settle that, then all you have to fight is ongoing medical treatment. Just be careful when you're doing the settlement documents, though. You want to make sure you put in the language to prevent future additional conditions from coming into the claim, and that you're paying medical bills only for the current allowed conditions. There are a lot of things to do when it comes to settlements. Again, that's one of the best ways to lower your claims cost and manage your claims. Use of job videos in the defense of a workers' compensation claim. You're going to think, well, how has this got anything to do with managing claims costs? It's huge. It's like they were saying on Seinfeld, it's huge, Jerry. You got to say when you're fighting a claim, you want to get a video of the job or of the claimant if necessary. The first assumption you have is that all the claimants are telling the truth when they describe their job to their doctor or your IME doctor. I have sat there before and listened, and I've been in hundreds and hundreds of plants. I've seen thousands of jobs. I know what these things are. And sometimes when I listen to a claimant describe a job that I've been to the plant and seen, I'm sitting there, are we talking about the same job? Because they will make it sound like it's hell on earth. It's the most heavy, ungodly job you can imagine, when in reality, it's a very easy job. So take a video of the job process, especially if you've got a claim where it's not so much a specific injury you're fighting over, it's whether doing a specific job has caused the injury. Videotape that job and send it to your IME doctor. I can't tell you how many claims I have won for that reason alone, because that gives you the argument that your doctor had a complete and accurate understanding of what the job duties actually were. They understand the mechanics of the job. They saw the arm movements, the shoulder movements. Whereas the claimant's doctor, all he knew is the claimant told him, I repetitively lifted all day, I turned, I shot screws, et cetera, et cetera. And that's that doctor, the claimant's doctor's understanding the job. So which doctor is in a better position to give an opinion on causation? A doctor who viewed a video of the job, or a doctor who took the claimant's generic description? So get job videos. We have one client who has a company come out and do the job videos, and it's professional quality. I've had other clients who go out with their cell phone and use a cell phone to make a video of the job. They text me the video, and I get that to the doctor. So you can do it any number of ways. But the key is getting the job video and getting it to your IME doctor. If you're going to use the job video, a couple things you got to keep in mind. If you use a video, it's going to make your IME much more stronger and reliable, and it's going to allow your doctor to understand the job itself. However, if you do use the job video, there are certain requirements you've got to do. The video doesn't need to be real long, and that's a misconception. You don't need a 15 or 20-minute video. You're just trying to show a job process. 5 minutes or less is more than enough. But keep in mind, if you video the job, you're going to give it to your doctor. That means anything you give your IME doctor has to be filed with the Industrial Commission and given to the other side with a description of the video. So be careful if you have any proprietary job processes you don't want out there for public consumption, you don't want to video that, obviously, because if you do, people are going to have copies of it. You have to give a copy to the claimant and their attorney. Who knows what they're going to do with it? So if you're concerned about confidentiality, don't do it. But again, if that's not a concern, video can be 5 minutes or less. If someone's doing a 5-job rotation, make sure you videotape all rotations of the job, just not one. I've had many claimants come in and say, well, it wasn't the first rotation that hurt me, it was the 3rd rotation, and the employer had only videotaped the 1st rotation. So just videotape the whole job rotation, and then you got it. And here's one of my big pet peeves: to tell your doctor, your IME doctor, review the video with the claimant during the IME. Because if they don't, sure as I'm sitting here, the claimant's going to come in and say, that's not how I did the job, or that's wrong, this is wrong. Have the doctor go over the video with the claimant during the exam, so that way, if there's something the claimant doesn't agree with, we can then say, our IME doctor was fully aware of that. They took that into consideration. You don't have to worry about at the hearing, now your own doctor's opinion is not valid anymore because the claimant says, well, that's the wrong job. You don't want to find out at the hearing table that the video the company gave you was not the job that they're alleging they got hurt on. So instruct your doctor to review it, and that will cut off a lot of problems in the future. And again, like I said a second ago, if you do use the video, you got to put all parties on notice that you've used it. You got to file a letter with the Industrial Commission, send a copy to everyone, giving a short description. Okay, this video was 5 minutes in length. It depicts the jobs the claimant was doing. But you got to send that letter, and you got to do it at least 2 weeks prior to the hearing. And it's probably a good idea to request extra time if you're going to want to do the video at the hearing. Another big thing is written job offers. And I can't tell you how much money this can save you as an employer. It takes some effort, but you got to do it right. And there are certain necessary elements of any written job offer you're going to use to terminate temporary total compensation. I've had clients ask me, well, just send me a form. There is no form for a written job offer. Let me repeat that. There is no form. There's no template. Every claim is different, and you've got to make your written job offer exact to your specific situation. You've got to offer a very specific job, identify the physical demands of that job, this exact position offered, describe the actual job duties, set forth the restrictions under which the claimant's going to be working. It's got to be clear that job is within the restrictions. Tell the claimant what shift, hours, when and where to report to work, the rate of pay. The more information you put in that letter, the stronger it's going to be. Because I can't tell you the number of times you come to hearing and the claimant's attorney is going to argue that job offer didn't identify the specific job duties he was going to be doing or how often he was going to be doing them. The more information you can put in that written job offer, the better. And a written job offer can help you get someone off temporary total compensation, which is going to save you thousands upon thousands of dollars. Keep in mind, a job offer cannot be supplemented by non-written promises. And I've seen this happen time and time again. Someone will go into the health center after they started on the job and say, hey, you know, this job, I can't do this job because of whatever. And the employer will tell them, okay, we'll modify the job or we'll do this, but it's never put in writing. Claimant then the next day doesn't come into work. A month later, you're at a hearing, and the claimant will say, I couldn't do the job because it wasn't within this restriction. The employer said, well, we told you this. And as soon as you say that, you're dead in the water, because when it comes to a job offer, everything's got to be in writing. Any changes have to be in writing. And be careful with your definitions. Don't use things like repetitive, instance, occasional. Repetitive, tell them, you will be lifting this 4-ounce part 3 times per minute, or you will be lifting this 5-pound part, 8 times an hour. You have to be that specific. Just don't say you will be repetitively lifting a 3-pound part, or you'll be repetitively lifting brake lines. Well, you may know a brake line weighs 1.5 pounds, but nobody else does. So you've got to be very specific. Do not be vague in these job offers. Well, I hope some of this has given you some advice on how to save different money on your workers' compensation programs. If you had any questions, you could write them in. If you're sitting at your desk and you think about after the fact, you have a question, just feel free to shoot me an email. It's rking@bugbylawyers.com. I'm pretty good about responding to my emails the same day. But if you have a question on written job offers, return to work programs, anything, don't be afraid to ask. And staying on top of your claims will save you a lot of money. So good luck.